slides here, so if you want to make notes on them, feel free. I'm going to go by them pretty much. I've added a few things to some of them, but each one, I'll try to go through it and give you at least my ideas. And remember, all of this is, whenever you're a judge pro tem, you're the ones who call the shots. And I'm going to tell you what I do, and probably tell you why I do it the way I do it. But that's no way I'm ordering you to do that. Whether we're doing good or not, that's not the point. But you're independent judges, okay? And everyone who is a judge pro tem is an independent judge. And you're taking an oath just like every judge, active judge, every commissioner, every referee. And it's a big responsibility. I kind of analogized it, when I was an attorney for 30 years approximately, and I got on the bench, I felt like somebody gave me the keys to a Ferrari. And I didn't know where all the switches were. And I certainly didn't know what the power was. And I just didn't want to crash. So I started off a little bit slowly, and I learned from other judges. I learned from the resources that we have. The bench guide is a wonderful thing. And, just realize the power that you have in dealing with people's lives. And the people that we deal with as traffic judges, they're people like you and I. They're not bad people. They're people you probably have over for dinner, most of them. And they're people just like you and I. And they can be extremely sincere in their attitudes, in their beliefs, in their guilt or non-guilt. And, it's like they come in here, they're priests, they're rabbis, there's college professors, especially in Irvine here. Oh my God, we get everything from UCI. I mean, their IQs are so much higher than all of us put together. And I've had the physicists come in and explain how the camera can't work properly unless it goes between, he stopped in between two frames of the video, of the officer's video camera or something. But it's amazing what they can do, and they are competent, and they are nice people, and they deserve every bit of respect. So I think it's really important when you're dealing with your clients that, and I'm saying clients, the people that are here on trial, that you give them the respect that they deserve, and that you don't talk down to them. One of the things I really do want to thank you all for is the time that you're offering here. I know the pay is not very high for being so, and I do know your time is valuable, and some of you can bill out, big money, like $100 an hour. That's big money. And here you are, you're spending that time for us. And on behalf of all the judges, Judge Silbart was the head of all of our pro tem committees and so forth. We do thank you, and we do appreciate you, because without you, it'd be really tough for us to take vacations. It'd be tough for us to do anything other than the daily grind, and as you all know, sometimes it gets to be quite a grind. So what I hope I can be able to do for you is to try to explain to you the things that you can expect as a judge pro tem. Let me go to, where's my little clicker? Here it is. All right. So the qualities of a judicial officer: you want to be patient, you want to be dignified, you want to be courteous, you want to be fair, but you also want to be efficient and expeditious if at all possible. And it's not unusual for us to have 100 people for an arraignment calendar, and somehow those 100 people, between when you start the calendar, get done with the calendar, they all have to be taken care of, and they all have to be treated with dignity. For most of them, they only have one experience in court. Most people who I sometimes ask folks, how many of you are here who never had a ticket before? Good half, at least half raise their hand. And the interaction that they have with the court, with the judges, that may be the only interaction they ever have with a court. And they take that with them. And believe me, there's not a party I go to, there's not an occasion I have when somebody doesn't have to tell me about their traffic ticket from 20 years ago and who the judge was, or not maybe who he was, and what he looked like, and what he said, and what the officer said, and whether they were treated fairly or not treated fairly. And that's why whenever I meet strangers, I always tell them I'm a retired attorney. They don't care so much about attorneys, but if you're a judge, boy, oh boy, you're going to hear stories. So, and that's because it's a special time for everybody, because they do come to the court, and hopefully it's a good experience for them. And every once in a while, we get some nice feedback. I've had people who have written me very nice letters. I've had people at the end of the day say, you know, this was so interesting. I'm going to come and watch even if I don't have a ticket. I said, that's great. Come by anytime. But we do try to keep it formal, proper, but also somewhat light. I don't believe that the formality, for example, people used to have formal openings, right? All stand, put your hands over your heart, or like that. In the presence of the flag of the state of California, and then for the county of Orange, Department 14, H14 is now in session. The Honorable so-and-so. Okay, you know what? It's traffic court. Mellow. It's not that formal. So that's not something that I ever do in a traffic court. I do it for jury trials. I do it for situations where it's called for. That's why it's called a formal opening. It's not just called an opening. Anyway, our opening is the bailiff has everyone come and sit, and don't stand, just department so-and-so is in order. All right. Now, first of all, the other thing that you want to remember, everything's being recorded, digitally recorded, because all pro tem functions, all commissioners are mandatorily recorded on digital tape, okay? It's up to a Superior Court judge to decide whether or not they want to have a proceeding digitally recorded. But I love recordings, and I'll tell you one reason why I love recordings is because every once in a while you'll have somebody accuse you of doing something you didn't do. And if you have that recording, you'll know that you've got some evidence to show, I never, said this or did that or implied that. And these folks, sometimes I've had some letters. Fortunately, I've been doing this since 2005. It's close to 15 years. And I've had, I think, 2 complaints. People accusing me of doing something, having to do, I don't even remember the details, but it was inappropriate or something that I shouldn't have said or made me feel bad or something. And so we played it. And it gets reviewed. They file a complaint. It goes to the supervising judge here, it goes to the presiding judge, and then it can go to the CJP, the Commission of Judicial Performance. But that's why tapes are so nice. Also, when you're doing traffic trials, have you ever had one appealed? If you have one appealed, you've got to do a 7th statement of facts. If you have that digitally recorded, all you need to do is order that the tape be presented to the appellate department of the Superior Court, and you don't have to write a 7th statement. Makes it really nice. So don't ever, well, you don't have a choice, but if just be aware of it all the time. Sometimes we record, I kind of call it the sounds from the bench. So make sure that you realize everything's recorded, and we've got the clerks are here, the bailiff is here, and sometimes you do things that you shouldn't be doing. You hear people yawning, you hear people chewing gum. I don't like it, but sometimes if pro tem is chewing gum, maybe it's like a little bit too informal. You need to provide dignity. If somebody's chewing gum in my court, I always ask them to deposit the gum in the trash can that's provided there, because I don't think it's dignified to be chewing gum in court, and it's certainly not dignified by a judicial officer to do it. Sometimes people say he was rude to me. The tone of your voice. Well, the tone of the voice is really recorded quite well, and it's loud. And the microphone for you is like pretty close. So your tone of voice can be shown. And every once in a while when somebody has a bad tone or maybe said something they shouldn't, and it's reviewed, it goes to Judge Silbar. Judge Silbar will call people in and say, hey, listen to this. Do you realize what you did? And oftentimes that's enough to say, I can't believe I did that. But anyway, so be aware. Everything is being recorded. Not to scare you, just add it to your consciousness. Also, mumbles, like, who's going to wear that to court? Yeah, I mean, sometimes I think it, but I don't say it. And anyway, so let me go to the next slide. And it says, the trial of a traffic infraction case calls for the talents of a person who understands the societal function of traffic law enforcement, is committed to its educational objective, and who has the personal capability of dealing with people expeditiously, fairly, and in good spirit. That's in a court case of 1978. Makes a lot of sense. All right, next slide says, you are not wrong. The most important people in this courtroom are not you, it's the clerks. And I'm very lucky, any of you who have pro tem here, and there's quite a few of you. Lindsay, hello Lindsay, you're still here, thank you. Thank you, Lindsay, for being my best helper ever. Listen to her, she talks to me. You don't want to be cocky, because you have no right to be cocky. And when she offers something, and if it's not her, you go in another court, you have a question about something, hey, do you know what the maximum sentence is? Is there something I need to know? Or if she offers something, I think you should tell a clerk, listen, I'm Judge Pro Tem, I really want to do a good job. Is there something that, if there's something that comes up, you need to talk to me about it? Pull me aside. Now, she's not going to interrupt you in open court and say, hey, dummy, you're not supposed to do that. But hopefully, and people are pretty respectful to you in most cases, and receptive to you in most cases.
Pretty much, yes.
All right. And she's a help, believe me. The bailiff is your big help because he or she will, tell you if there's, insurance is valid, driver's licenses are valid, so on and so forth, and that moves things along. All right. Now, efficient calendar management. That's what we want to know. That's what we want to do. I'm on page 5 here, so, oops, wait a minute. I'm ahead of myself. All right. When people come to the court and see you at arraignment, they have that ticket for about 6 weeks if they didn't get an extension. If they got an extension, they had the ticket for about 2 months. And if they walk into court and say, I haven't had a chance to fix my window yet, can I get an extension? Well, when I first started out, I used to think that was fairly reasonable. And I'd give them an extension, and then I'd see him again in a month. My daughter had to go to school, my wife had this, my this had that. Can I have another 2 weeks? Well, it's only a cracked window. Anyway, you get repetitious appearances, and it's not necessary. That just adds appearance. I never ever, and I'm sure it's happened, but I never continue a case to show proof. What I do is, I say, can you take care of this within 30 days? Yes. If you'll plead guilty, you've already had 6 weeks, you've already had 2 months. If you'll enter a guilty plea today, I'll fine you whatever I think's appropriate for the violation, maybe $10 for not having a front license plate on the car, 10 plus penalties. I'll give you a stay of 30 days. If you show us proof of correction, it's dismissed. If you don't, pay the fine. Is that fair? Yes. And you won't see him again. You still might see him again, but at least there's some finality to the violation. And I do that with everything, from registration, from proof of cracked windshield, lights, anything is defective. Anything that they can show you proof of correction, please don't continue an arraignment. Some people want to delay and delay and delay and delay. And that's not fair to the other side, because we'll be talking about this. Obviously, you're an arbitrator. You're a judge. You want to be fair to both sides. Now, in traffic court, we don't have the benefit of having a prosecutor. So there's no plaintiff, if you will. You're only dealing with one side. The people, the district attorney, they have a right to have a trial within a reasonable time, as well as the defense. They have a right to the resolution of a case. The DMV has a right to have an accurate record of someone's driving habits. And I'll get to that a little bit more. So you've got to take care of both sides, not just one side. Also, an infraction is expunged after 3 years. I know that there are some people who manage to delay their cases for at least 2.5 of those 3 years. And it goes doing things such as going to a lawyer and then changing lawyers, or saying they're going to hire a lawyer, and then that's another thing. do you want to have a lawyer? Sure, you're entitled to a lawyer, and I'll give you that advisement. And if that, lawyer, if they're really going to hire that lawyer, what I'll do is say, I'm going to give you a date. That's the date for trial. If it's not convenient for your lawyer, he or she knows how to come back and ask the court for a new date. Not, I don't know when my lawyer's available, could you continue the arraignment for a month? No. Sometimes if they say, I already hired a lawyer and he told me any date's good, I said, well, they go out in the hallway and tell them X number is the date. If it's good, that's fine. Because sometimes lawyers don't realize that certain cases have to be heard on certain days of the week, which we'll talk about. Don't know about that yet. So it requires legal trust. I tell everyone who's at an arraignment court that they can have what other payment option that they want. Now, I'm going to do my arraignment speech for you in a couple of minutes, but I'm going to talk, I just want to give you some highlights. One of the things that I tell them, and especially in this day and age where the issue of ability to pay is a very real issue, a lot of people are hurting, and everybody should have the ability to pay the fine in a way that they're capable of doing it. But I don't believe that that means they don't have to pay fines. I believe that that means that they should be able to pay the fines in a way that they're able to do it. So what I tell people is that when I set a fine here for you, I'm not going to ask you how you're going to pay for it, and I'm not going to discuss with you how we're going to pay for it. I'm going to give you 4 different payment options. You can pay it today, you can pay it in 30 days, you can pay it in 60 days, or if you wish, you may set up a monthly payment schedule based upon your ability to pay that the collection department is set up to do. And I also tell them that the collection department also has it within their power to convert a portion of their fines to community service. And then I'll say something effective. I've never thought it was appropriate for a person to have to stand up here in front of a room full of strangers and explain to me that they recently had their home foreclosed upon, or that they lost their job, or that they've had illness in the family, or that they are retired and that they're on a fixed income, or that they're a student and they don't have any income, or that they're disabled. Those are all very valid and important issues, but that's something that our collections people are set up to deal with. That avoids all of the discussions of money in your court. Now, if discussions break down, they can always come back and see me, but I don't, emphasize that. But the collections folks are really set up for that. And we're very lucky in this county that we have that kind of a system, because most counties don't have it. Only the bigger ones have it. But the legislation that recently came in it's called the ability to pay forms. Those are brand new, started April 1st. And basically says, what do I do if I can't pay my ticket? There's a form for that. They have you fill it out. Now, what Sacramento says, well, everybody should be able to avoid paying their fines. And I mean, we've never, in my experience, 15 years, I've never put somebody in jail for not being able to pay their fines. People who fail to comply with the court's orders, such as going to the clerk's office, they could end up going to jail. Usually anyway. But we don't have debtor's prisons. So if you can't afford to pay it, there's alternatives. There are guidelines in collections that say, look, if they're on public assistance, they can waive most all of the fines. There are guidelines that if they are on SSI, disability, they're not going to have to pay. There are guidelines that if they are receiving public assistance for education, if they have student loans, that's all taken into consideration. I don't think I've ever been competent to make a determination, should this person pay $25 a month or $35 a month? Or is this person lying to me? Is this person exaggerating their needs? That to me always wasted an awful lot of court time. It embarrasses the people that had to be asking for it. So at least I do it. I mean, I know that there's judges in here right now who have just, say, okay, when can you pay it? Will you pay it in 60 days? No, Judge, can I get 90? Okay, you can pay it in 90 days. Or, and then you tell one person they pay 90 days, and one person goes, why do you ask me to pay in 30? You let him do it in 90. That's not fair. So I do avoid discussing money in court. And I explain to them why. And I'm explaining to you why. And I'll stand behind that. I also tell them, in most cases, I will not reduce fines for moving violations. The bail schedule is set up in the state for some consistency throughout the state. It's based upon the ability to pay. Excuse me. It's not based on ability to pay. It's based upon your prior driving record and the nature of the violation. Now, there's a reason for that. It's, the average price. Sure, $35 turns into $238, $70 turns into $367, $100 turns into $490. There's a crazy math involved with all of the real fines, out-of-pocket fines versus what we call a fine, and that causes all kinds of confusion too. But I don't think that if they go to one judge, they should get a deal, and other judges, not such a good deal. And if somebody comes to me and, well, there was a letter I received that a judge in court gave someone a fine of $10 plus penalties for a particular speeding ticket. And this person who was writing the letter says, I had the same violation because I know the girl that had it, and the judge told me I had to pay $35 and she paid $10. And I think the reason is that she smiled at him nicely and I didn't. Isn't that discrimination? Yeah, damn well discrimination. So I get people in here every day who, I tell everyone up front that I won't reduce moving violations. And sometimes they ask. And they may say, well, I hope you don't mind if I ask to reduce the fine. I said, no, I don't mind that you ask. And you're asking in a polite way, and that's fine. But it's not fair to the person who received the citation in the mail at home that has the same record as you and did the same thing as you, that if only they'd come to court, they'd get a deal, and they're working or can't afford to come to court or choose not to come to court or choose to admit their guilt at an early stage. And they've got to pay more than you just because you came to court and asked. So that's my philosophy. I know there's judges around here, and they'll be remaining nameless, who, when they sit in traffic court, not the regular, I'll call them regular traffic judges, other judges, the first thing they say is, well, this is your lucky day. I really do felonies. I really take care of murderers and kidnappers, so I'm going to reduce your fines. How's that? Right? Yay, we love you, Judge. And $5 for insurance violations, $10 for speeding tickets, $5 for this. And I look at it, and to me it's such a disparity that's just so unfair to all the other people. But those judges feel, I don't know, I'm not sure that they just don't want to do traffic, or that traffic is so de minimis in the world of reality that, why even bother? So, but I cannot criticize their judgment. I just differ with their judgment. And you may walk out of here and say, Delina's nuts. I'm going to give deals because, if somebody goes 81 miles an hour, it's 70 plus penalties. And if they go 79 miles an hour, it's 35 plus penalties. Maybe we should just split the difference. And that's, when I started off, I did that. And I'd say, oh, well, it's only 1 mile, so let's give them the break. Let's give them a break here. And then I started to realize there's got to be a break somewhere. So if you're going to give them a break for going 82 instead of 79, well, how about 83? And then, well, it's only one. Anyway, so, and the people that are in the audience, because they're all looking at each other, they're all looking at what you're doing, and they want to be treated the same. So if I'm comfortable being consistent. So I did a lot of different assignments. I started off doing traffic in Fullerton, and then for a number of years I did jury trials in Fullerton, open court, post-conviction calendars. I did the felony calendar here, and then I went back to traffic. And that was about 2013, 14. I started back in traffic, and I've been in traffic since. And when I came back, I kind of did a resolution. I'm going to stop worrying about making up my own amount for the violation, I'm going to follow the bail schedule, because that way I know I'm being consistent. So that's how I do it, and I tell people that's how I do it, and so they can expect it, and I can be consistent, and nobody's going to write me a letter saying I gave somebody a break that shouldn't have had one. Anyway, where are we? Let's talk about this. Other issues, requests for, oops, page 6. Okay. Requests for trials by declaration must be done prior to the first appearance under 40902. Okay, if you go on the internet, they say do trial by declaration. Everyone's entitled to do a trial by declaration. Trials by declaration were started about 30 years ago when people in San Francisco would get a traffic ticket in Los Angeles and say, "That's not fair, I can't drive all the way down there for a stupid traffic ticket." So they enacted a law where basically says that if you live in a county that's more than 100 miles away from the county seat, that you're entitled to do your trial by declaration. That went on fine for a little while, and then the local attorney said, "Well, that's not fair. Why are you discriminating against us?" And they said, "Okay, everybody can do trial by declaration." And here we are. I've got people who live in Irvine doing trials by declaration. When to me, if they're entitled to do it, it's statutory. I read it, it must be done prior to the date of your first appearance. That means if you show up to court and say, "I want to do a trial by declaration," you've blown it. Okay, you've got to do it before your first court appearance. Now, if they show up to court and say, "I want to do a trial by declaration," and their appearance is a month from today, or 2 weeks from today, I allow the trials by declaration. But it's not a constitutional right to do a trial by declaration. It's statutory. And I strictly construe that statute because I really do believe it's just a device, it's an abuse that a lot of people utilize just to try to get the officer to not have to, write their response and, "Hey, I won the ticket." No, you didn't win the ticket. Cop had something better to do than write a response to your trial by declaration. It's okay if you feel differently about it, but that's how I look at it. And people will come in here and they say, "I'd like to do a trial by declaration." Well, you're here. What's the problem? Let's go to trial. And also, it requires that you post the bail. Okay? Or they come and ask for a trial by declaration without doing it. Well, no, you have a right to a trial, but you don't have a trial by declaration unless you post the bail. Anyway, that may change at some point in time where everything's going to be by declaration because there is a move afoot that eventually they want to do away with traffic trials altogether. I don't know if anyone's heard about that. It's kind of brewing right now. There's a request for opinions and responses and all of that kind of stuff to try to save money, to change traffic trials to having strictly in writing. Also, the preponderance of the evidence would be the order, not proof beyond a reasonable doubt. And that's coming up. I don't know if that's going to change. I doubt it. But, the lawyers certainly don't want it to happen. And quite frankly, I'm not sure how fair it is to the public or to the officers or to the public. So we'll see. All right, another device that a lot of people use to try to get out of their ticket is 40502B, which is a request for the county seat. You do have a right to request the county seat. And that came up out of San Bernardino County where people in Needles were getting tickets and having to go 100 miles away to San Bernardino to fight their ticket. And so they can request a county seat. But I read that it says at the time of the arrest. That means that the defendant, when you receive the citation, "I want to have my trial at the county seat because my office or my home is closer to the county seat than it is to that faraway court in Harbor Court." Okay? I mean, our county is ridiculous because where's West Court, North Court, East? I mean, we're not very far away from each other. And, sometimes people read it in a book and say, "Okay, I want the county seat." Well, if they come to my court and they start asking for a county seat, I'd say, "Sorry, it's not timely. You had to ask for that at the time of the citation." Now, officers, I've had some cases where officers refused to honor it and told him something to the effect of, you just have to ask the judge about that. So somebody came from, they received the citation. Where was it? Oh, it was here in Costa Mesa at the time that we were doing it. It was Costa Mesa. And the defendant said that that's what happened. And I said, well, if that's what happened, then the officer made a mistake. So we had the trial. He showed up at trial. And the only question that was asked at first was, officer, did he ask for county seat? Yeah, he did. And did you give it to him? No. I told him that you could do that for me. He said, well, yeah, I could. But the whole idea is to avoid him going to that far distant court away. So, officer, you're wrong. And I dismissed the ticket. So I'm consistent on both sides of it. So they do have to, and when officers ask about it, they do have to grant that. They're only supposed to do that if the defendant's office or home is closer to the county seat than it is to where the citation was issued. And you can't ask for North Court if you got the ticket in southern Orange County. You can only go to San Diego. It's got to be the county seat. All right. Okay. Sometimes people come to court and say, hey, I just want to plead guilty, but I don't have the money today. So obviously I give everybody stays and so forth. But I don't do it. I send them to the clerk's office, and they choose. So I always tell them it's their choice. Now, a couple things that I think is not a good idea, and it's you've got an obligation to follow your obligations as a judge. Don't give advice, just give options. People oftentimes say, well, Judge, what do you think I should do? And, I said, I'm not a lawyer. I can't be your lawyer. So I can only give you what options are available, and I do that. Don't negotiate, please. It's so unseemly. Somebody will come and say, well, Judge, I'll tell you what, I won't go to court if you'll reduce my fine to $20 instead of $35. And I tell people, no, you can go to court. I said, I won't do that kind of negotiating. And I usually, my line is generally, is there some reason I should treat you differently than everybody else is being treated? And usually they kind of back off on this. And I tell them again, I try to be fair, I try to be consistent, I try to treat everyone the same way, that has the same violation, has the same facts and circumstances and the same history. Also, don't overly personalize issues, especially, and again, this is from listening to some of the transcripts from pro tems. Sometimes they kind of go, you got to start talking about what happened to you when you were a little kid. And I once had a police officer who gave me this warning and so on and so forth. And folks, nobody really cares. Don't try to be a comedian. You can be a hypnotist or a magician if you're really as good as Evan is. He does magic. It's incredible. And somehow that comes up. I don't know if that comes up in trials. No, you don't make their cases disappear, right? But he did some card tricks for us earlier, and he's amazing. But you're not Jimmy Kimmel. You're not a comedian, and just do what you have to do. It's annoying, especially for all the people that are waiting for you to get done, having a little ego trip. Don't badmouth the system. Sometimes I hear people say things like, these fines are ridiculous. Well, if you think so, that's fine, but not in court, not from the bench. For example, right turn on a red light is if it's a right turn, if you don't stop at a red light before making that, that's just as expensive as if you blow through it at 40 miles an hour. Does that make a lot of sense? No, not really. But I hear people, I guess to create some sympathy, so the pro tempers are going, this is really a stupid fine. I guess you have to pay it, or do you want to pay it? Don't. It's just not professional. It's not judge-like. So please don't badmouth the system. Don't badmouth the violations and so forth. All right. Now I'm going to give you an example, my example of how I have been doing rights for the last 10, whatever, 6 years at least. So if we can role play a little bit, please. You're the audience, so I know you're all I know you all, I know who you all are, so please don't feel like I'm talking down to you, but I'm talking to the audience of lay people, okay? And it's not that you have to do it this way, I'm just telling you this is the way I do it. And kind of one of the principles that I'll tell you right now is I try to anticipate the questions that they're going to ask and answer them before they have to ask me. And the benefit of that is several times, just a couple days ago, yesterday, somebody came up and said, well, Judge, I had a lot of questions when I came, but you answered them all before we even got started. I'm going to, whatever he decided to do. Because I think it's a smart way to do it. So let me start my acting. All right, good morning, ladies and gentlemen. Welcome to traffic court. This is the arraignment court. Arraignment is the first stage of a criminal proceeding. It's at this time that you can enter a plea of guilty or not guilty, but this is not the time for a trial. It wouldn't be fair for me to listen to the police officer's side of the story without you being there and for me to find you guilty. Likewise, I can't just listen to your side of the story without the officer being here in order to find that you're not guilty. So if you'd like to have a trial, we schedule trials within 45 days. That's your statutory right to a speedy trial. At the time of the trial, you have the right to cross-examine and confront the witnesses against you. You have the right to testify, but you'll not be required to do that. And you also have the right to use the court's powers to obtain witnesses or documents that could be used in your defense. You do not have a right to a jury trial. You also do not have the right to the free use of a court-appointed attorney. You may hire an attorney anytime throughout these proceedings, but in order for the court to be required to hire a lawyer for you, your liberty must be in jeopardy, and none of you will be going into custody today for your traffic offenses. If you'd like to plead guilty, I'll impose a fine, and in some cases, a license suspension may be in order. The amount of the fine is determined by two factors. The first is the nature of the violation, and the second is your prior driving history. Nature of the violation simply means that some violations are more expensive than others. Red lights are more expensive than stop sign violations. They're different than lane change violations. They're different than cell phone violations, and so forth. They all have their own prices. The second factor is your prior driving history. And what that means that if this is your very first offense, if you've never been in trouble before, if you've never even been pulled over by a police officer, you'll be paying the least. If you've had one or more violations in the past, then depending upon how long ago and how far apart those violations occurred, you'll be paying somewhat more. So as you see, it's kind of a personalized calculation. It's already been done for you, and it should have been communicated to you by way of the courtesy notice that was sent to you in the mail. I won't deviate from what's on that courtesy notice for moving violations. I believe everyone who commits the same violation and has the same or similar driving history should be responsible for the same amount of penalty. Do recognize, however, that some of you may be in a more difficult financial situation than others, and because of that, we give everyone 4 different payment options. When you leave the courtroom here today, you will convey your choice to the people at the clerk's office. Your choices are as follows. You may pay it today, of course. You may pay it in 30 days. You may pay it in 60 days. Or if you wish, you may set up a payment schedule which is based upon your ability to pay. And that ability to pay will be determined by the people at the collections office who are set up to interview you about your income, your assets, any programs that you may be participating in. They're set up to do that, and they will work with you. And they will try to make this fit into your payment schedule and your ability to pay. And it's even within the power of the clerk's office to waive portions of your fee and let you do community service. This is also the time to ask for traffic school. In California, the Department of Motor Vehicles decides who's eligible for traffic school, not judges. The judge's role is simply to determine if you should be allowed to go to traffic school. Now, I make it a practice here that everyone who is here for the first time at arraignment and requests traffic school and is eligible for traffic school, I'll send to traffic school. I won't look any closer at the case or at the person that's involved here. You may go to traffic school today. The Department of Motor Vehicles allows you to go to traffic school once during an 18-month period of time. And again, that's based upon the date of the violation for which you last attended traffic school to the date of the present violation. If you manage to go more than once during that time period, the second traffic school is just ignored by the DMV. I generally have a record here in my file of when you last attended traffic school, and I can tell you whether it looks like you qualify for traffic school. But if you signed up for traffic school in a different county during the last few weeks, or last few months, it won't be in my computer yet. And it'll look like you qualify. And if you ask me, then I'll let you go. If I let you go, you must complete it, you must pay for it, you must show us proof, and then when the time comes for us to send that information up to Sacramento, they simply ignore it. So you've wasted your time, you've wasted your money, and fooled nobody but yourself in trying to go to traffic school if you're not eligible to do so. Now, many people ask me, will I still be eligible for traffic school if I don't take it today and decide to go to trial? And the answer to that is yes, your eligibility doesn't change. However, I take more factors into consideration if you decline traffic school at the first opportunity we gave it to you. We offered it to you. I take the following factors into consideration if you decline traffic school up front. First of all, have you ever been to traffic school before? Because although you may be eligible for traffic school every 18 months, it doesn't mean that it is designed for you to go to traffic school or get a ticket every 18 months. I've seen people in my experience here in the court that have done traffic school 3 times in 5 years, legitimately, honestly. They did the traffic school, and here they are with another ticket. So I'm not certain that traffic school does a great deal of good for you. So sometimes people will say, well, Judge, if once I get convicted here, now I really think it'll do me a lot of good. Well, I don't necessarily think that's true. So that's a factor I would take into consideration if you've been to traffic school before, if you wait until after you're convicted. Secondly, I look at the nature of the violation. There are some violations that I consider more serious than others. For example, going 75 miles an hour on the freeway is a violation. You can do traffic school for it. But I'm not as concerned about that as a violation than going 50 miles an hour in the school zone. 50 miles an hour, you can go to traffic school in the school zone. But to me, that's a more dangerous violation. I would take that into consideration. Also, the citations that allow traffic school are considered as average violations. For example, if you go through a stop sign at 5 miles an hour, 7 miles an hour, that's one type of a stop sign violation. If you blow through it at 50 miles an hour, that's another one. I'd consider one more serious than the other. So that's the kind of factor I take into consideration. Also, I look at your overall driving record. If you've had some problems in the past, it's also less likely that I would send you to traffic school because I believe your driving record should reflect your driving habits. So if you've had problems in the past, it's less likely I would send you to traffic school. And finally, because the officer's been subpoenaed here to court, I ask the officer, anything unusual about the car stop? And oftentimes the officer will say everything was fine. And sometimes the officer says, well, Judge, I'm glad you asked. I walked up to the car, the person was so rude to me, he said that I should be looking for real criminals rather than worrying about people rolling through stop signs, and that don't forget you work for me. And he wouldn't sign the citation. I had to call the sergeant. When I gave him the ticket, he wrinkled it up, and I almost gave him a liberty violation. So you can imagine if I get that kind of input, it's another factor that I would take into consideration. So I will say that if it's to your best, that it's important for you to keep the point off your driving record and to mask the conviction from the insurance companies. Now's the best time to ask for traffic school. And then I go into, however, if you want to set your case for trial, our trials are all held Mondays through Fridays at 1:30 in the afternoon at one of our justice centers here in Orange County, either North Court, West Court, Central Court here. The location of where you'll be assigned is determined by where the citation was issued, not where you are being arraigned. The day of the week is determined by which police agencies are involved, because different police departments come to court on different days. If I give you a date, or I will give you the proper date within the proper time period, and if that's not convenient to you today, let me know that, and I can give you a different date. But if you accept the date today, then it will only be changed by way of legal reason, and that's not easy to come by. So if you need to check your calendar, or if you'd like to go out in the hallway, you can bring it up on your cell phone. Make sure that the date that I give you is a good date for you. And if you need to change it, we can. If you change it, however, if you ask to change it, it must still be on the proper day of the week that the police agency comes to court. And you'll need to waive your right to a speedy trial within 45 days, because the date I'm giving you is that date. If you're asking for a different date, it will probably be beyond that. As long as you want to, if that's okay with you, you just have to acknowledge that. So now, parenthetically, this is something that I do that some people don't do. Everyone who sets a case for trial is entitled to bail. I set bail in an amount that's roughly equivalent to what the fine would have been had you pled guilty. We do that for a number of reasons, but primarily it's because if you can't come to court on the date that you were supposed to be in court for your trial, and you've posted bail, you simply forfeit the bail. There's no further court proceedings against you. You're not in trouble. Now, some of you may say, well, I can't afford to post that bail. And if you can't afford to post bail or choose not to, then you may be released on your own recognizance. Being released on your own recognizance means you sign a written promise to appear, which we do at the end of the calendar. And it is a signed promise to appear form, not just a verbal promise to appear. That's for you guys. It's a signed promise to appear form. If you then don't appear in court on the date that you promised to appear without legal cause, then the court can issue a warrant for your arrest because we have no bail that you posted. Or what we do in most cases is not issue a warrant, but we do add a civil assessment, the amount of $325, which remains on the case whether you're ultimately convicted or whether you're found to be not guilty. If you posted bail and you're found not guilty, then you get a refund of your bail money. If you posted bail and you're convicted, then we take the bail money that you posted and apply that to the fine. Sometimes it's the whole fine. Sometimes it's not the whole fine. Sometimes it's only a portion. But that money is yours to do with as you please. So just like anything else in life, if you can afford to post bail, by all means do so. But if you cannot or choose not to do so, then we'll certainly release you on your own recognizance. Let's see. I think I covered pretty much everything. Then I advise people that we're going to be calling you up roughly in alphabetical order. We have a number of different categories, so if we go by where you think your name belongs in the alphabet, don't panic. It's just that you may be in one of those other categories. And then if you have any documents that you need to show me, you have to show me proof of correction, proof of insurance, proof of a driver's license, or anything else. Have that out, have it available so that you don't have to go hunting through your file folders or your pocket books, and because otherwise you'll have a room full of people standing there looking at you wondering why you didn't have out what it is that you needed to show us, because it shouldn't be any big surprise. We know what it is that you're here for. So with that said, folks, then we'll call a calendar. All right. Now, let me back up and talk a little bit about part of my advisement, and that's the issue of bail. I found that posting bail is good for a lot of different reasons. First of all, it is a right. You can post bail. The benefit of it is bail gets forfeited, no further proceedings if you don't appear in court. Now, there may be various demographics in different courts. Downtown Santa Ana may not be as practical to have people post bail. You still have to give them the opportunity to do that. But here, I get probably 80% of the people that are setting cases for trial will post bail. Now, I also ask that they sign a written promise to appear. Some judges neglect to do that. Some justice centers have kind of not done that. I've always done it, and the only reason I do it, first of all, is to show the formality and the seriousness of their commitment to appear on the date of the trial. And secondly, if they don't appear on that date, and I have nothing in writing, I'm not comfortable in issuing a warrant for their arrest. If I have that signed document, and in fact I overlooked that, but I explained that it's a misdemeanor to fail to appear after signing a written promise to appear, and that's why you can issue a warrant for someone's arrest. Not for the infraction, but for the failure to appear. So I think it works very well. It also encourages people to post bail if they don't want to wait until the end of the calendar. Have a seat. I'm not discriminating against you because you can't afford to do it. But if we need to fill out forms, then have a seat, like get to the end of the calendar. And I've had people say, well, how much longer is that going to be? You know, maybe another hour, maybe a half hour. But to them, it's worth it to go post the bail. I'm not taking their money from them, but it's helpful because people do change. Yes, sir?
Just really quickly, a few years ago, I think it was Judge Silbar, circulated a letter indicating that the county as a whole had opted to issue civils in lieu of a notice of failure to appear. Has that changed?
No. We don't issue warrants for failing to appear. We can issue a warrant for failing to appear after the court's order to appear. So, yeah, when you sign that OR, what you're talking about, I believe, is when you receive a citation and you fail to appear on a citation, then that's not an order by the court. It's an order by the officer that you agreed to. And yes, they used to issue warrants, and people used to go to jail for speeding tickets. That hasn't happened for many years. They started doing civil assessments about 2003 or 4, I believe. So, and that was a statewide thing. And I mean, there's things that were done in other counties that we don't even think of doing here, which is put people in jail for traffic tickets. We don't. But that's something that has changed. And civil assessments. What civil assessments do, by the way, is that's money that gets generated for the trial court, benefits of the trial court. The court directly makes money for the civil assessment. Yes?
I'm not clear. I do this in LA, so I'm trying to figure out over there when there's a failure to appear, it's like 470 something plus other things. The civil assessment is not mandatory, it's discretionary.
It can, well,
it's
how do you get somebody to comply if you don't either issue a warrant or add a civil assessment? You just stay in the system. See, now you don't have to be the one to do it. The clerk's office will generate it. If you refer it for non-compliance, in other words, you don't actively have to issue the civil assessment. You refer it for non-compliance. They then send a letter to the defendant and say, if you don't come to court within 10 days, then the $300 assessment will be imposed. And then if they don't, then it gets imposed. So yes, you're technically not doing it, but you're referring it.
I think she means when they come, when they show up, and they have this, they want to plead, they want to take care of their matter.
Yeah.
And they have a civil assessment. They give the judge the discretion to just deal with the violation and dismiss the civil assessment.
And I do that every day, and I do that all the time. I'll get to that with civil assessments, but that's a big part of what we do.
And is the failure to appear, the 400 something, 70 something, is that mandatory? Can you deviate from it and just, when they give you a good example, which we do?
Well, if you have legal cause for, a good cause for not being. We also say that civil assessments, if you were in custody, if you were deployed in the military, if you were ill, provide us documentation of that, and that, of course, will excuse a civil assessment. The civil assessment gets imposed if you fail to appear based upon the signature on the citation. Okay? That signature on the citation is the failure to appear. Some people say, well, I didn't get a courtesy notice. That's not an excuse. A courtesy notice, I sometimes say, it's like your mommy calling and saying, hey, don't forget, you got a ticket. You got to be in court. That's what a courtesy notice is. That's not what we base violations on for civil assessments. So, yes.
I did pro temming this morning in traffic, and when you get a civil assessment, it seems the DMV suspends your license.
On a failure to appear, the
Right.
civil assessment, the consequence of a civil assessment is $325, and DMV gets notified. They suspend your driving privilege. It's reinstated when you appear in court. Appear in court means you can enter a plea guilty, you can enter a plea not guilty, you can do traffic school. Once that happens, then an abstract is sent to the DMV, and then they should reinstate your driving privilege.
Right.
So even if you don't pay it.
They do come in once they get their.
Well, that's a good way it's a reminder, yeah. get them every day, yes,
So if at arraignment they can't post bail
yes.
and they sign your form, as a general rule then, when they do not show a trial, do you issue a warrant?
No.
You don't issue.
I look at their driving history, I look at the nature of the violation. You know, if it's going over 120 miles an hour, probably. If it's, you know, 85 on the freeway, certainly not. Then what I do is add a civil assessment. But we'll get to that when we do trials and no-shows and trials. Anything else right now? Yes?
On the 4 options that you offer now, 30, 60, and collections, sometimes they're not sure, and,
I don't ask them.
no, but
I just send them across the hall.
60 days to pay the fine or report to collections?
No.
Okay.
Immediately, report to collections now, and they then let collections or the clerk's office know if they're gonna pay it today, at 30, to 60. No, they have to, and I'm glad you mentioned that, tell everyone, and the bailiff basically tells everyone, you know, be advised, when you leave the court, you must report to the clerk's office for further paperwork, basically. If they don't, then we get a list at the end of the day, people that don't show up there, and I do issue warrants if they don't show up, not if they don't, you know. And that's why I never give them, I don't give them a 30-day stay from here, get it from there. Make sure we have the correct mailing address, make sure we have the contact information. So I leave that to the clerk's office. Yes, sir.
Do you have, when we sit on these, this advisory committee is rather long, is there a form or cheat sheet that will
Well,
help us in here?
What?
Is there a script you're gonna
Yeah.
show?
Tape recording or something?
I'm not sure my script is ever the same 2 days in a row, but,
Should have recorded you.
well, they did.
You have recorded?
Have it transcribed, no. I mean, I don't mind providing something, but there are so many scripts, that's why I say it's mine. You can get the script from the bench guide, and, you know, the scripts are all over the place. What I like about, not like, now I feel like I'm self-promoting. The reason I say it the way I say it is, I don't say you have a right. I explain kind of what the rights are, explain why they can't have a lawyer, because sometimes I want a public defender. Sorry, you can't. And then I have to explain why you can't. Or somebody say, the fine's too high. Oh, and one thing I didn't say is what civil assessments, penalties, and you know, why a $35 fine ends up being $238. So I do mention that from time to time too. But what I always do is I give them the bottom line. I give them the bottom line. Not, I generally don't say 70+ penalties. Now it gets a little tricky because the fines have enhancements for priors. And I'll show you that on ELF in a minute. And that's another reason why I like to go by what the number says on the screen. It tells you what their penalties are. You don't have to make it up. You don't have to decide shall I impose or shall I not impose prior enhancements because they require it. Yes?
Now, when you were saying that there's a range and that when they get their ticket, it's taken into, when they get their notice, the reminder I'll call it, it takes into consideration what their situation is. So that must be a computerized thing
Absolutely.
that says no other tickets. blah, blah,
Exactly. That's all generated by the computer. And, yeah, exactly. That's what that is what it is. Yes?
So do you have like a form where we check mark, like, you know, take community service, half payment, half community, things like that, so we do for,
I send them to the clerk's office.
so there's no form?
I don't have a form. I mean, look different. Some of you may have done it differently, and I know some of you have done it differently. You say, can you pay it in 30 days, or can you pay it today? Can't pay it today? Okay. Can you pay it in 30 days? No, can't do it. Okay, how about 60 days? Okay, you want payments? Okay, we'll do payments. Why? We don't need all that. We don't need, I don't think it's dignified, quite honestly. Why make people say what their source is, what their problems are? You know, it's, yes.
The reality is, like in West Court,
Yeah.
you're supposed to ask, can you pay today?
No, you're not supposed to.
Only because if you stay until Friday, so when you get the paycheck, or 30 days, it has to be by your order. If they go to the window and they don't have that order from the court, then they have to come back and ask for it, otherwise they tack on
That's
the,
why,
they tack on the $35.
and that's why you, okay, that's why I make it an order that all the cases that come out of this court can choose to pay it today, 30 days, 60 days, or monthly payments.
Oh, I didn't
It's a
realize that.
blanket order. Everybody has that order.
Just Harbor.
Well, it was North Court when I was working there.
Well, I'm
But,
just
you know, we've
trying to
had new
figure out.
commissioners coming in. We've had new commissioners coming in at different courts. And I honestly, I haven't spoken to our new commissioner, Commissioner Van Camp at West Court yet. I think Laz does that. You should, who works at North Court? Don't they give options that way?
Yeah.
What I do is I tell the people, do you want to make payments? And if they say yes, I say then go to the window, they'll make the arrangements.
Right.
I don't say to them, are you too poor to
Well,
pay it?
that's fine. I
But
mean,
does that mean that they
that's it.
pay an extra, what I'm hearing is they pay $35 if there's not magic
Third
language,
installment.
you know?
Yeah, if they make installments, it's an extra $35, but I
Yeah,
have
that's-
the window tell them.
well, yeah, I leave it up to the, I don't know. To me, I spend less time spending time talking about something that they're gonna deal with at the clerk's office anyway.
Yeah, they have to
You
go
don't
to the
need
clerk's
to-
office anyway, you give them 4 options.
Yeah,
It's not, let's make a deal, they go to the clerk's office, and if they're gonna make a deal, they make it over there.
exactly.
You save a half hour, at least.
At least, I'll guarantee that, and yes, easily.
And some of the courthouses pay today and go to one place, and other lines go to a different place.
Well, let's put it this way.
Central and West are that way.
Let's put it this way. If that's the case, that can be changed, okay? And I'll talk to Van Camp about it. Because that's just something that we can do.
I
Yes,
was just gonna say, it needs to be uniformity, so we don't make a mistake.
okay? All right. Now, I think what I'm going to do now is, let me see that. Oh, yeah, let me talk about diversion real quick at, well, let me back up, I'm sorry, we got a little, let's go to number 10. Page 10. Okay, traffic school at arraignment. People may ask for traffic school that are not eligible for traffic school. There's some violations that do not allow traffic school. They'll be reflected on them. But, for example, cone pattern violations, if they go through a flare pattern, not allowed. Nothing you can do, we can do about it. It's a DMV rule. There's a crossing guard violation. If you don't obey the crossing guard, no traffic school options available. They are points, and they remain points on your driving record, but they don't have an option for traffic school. Now, the cell phone violation is something that's come up lately. And cell phones do not carry points on your driving record. However, I've had people coming back saying that their insurance has been increased as a result of a cell phone violation, and that their insurance guy said, if you go to traffic school, then we won't have to do that. So I've had so many people come in and ask that I am advising that if they want to do traffic school and are otherwise eligible, they may do it, but understand you're not eliminating a point, but you are masking the conviction from the insurance company. So I'm just that's something like within the last 6 months that I've been hearing. I don't know if any of you had people say that or not. But, also, there are non-point violations, seat belts, cell phones is non-point, being in the HOV lane, in the carpool lane, toll road violations, of course, don't have points on it. Here's one that a lot of people have been, in my opinion, getting away with for years. They'll not do their traffic school on time. Now, you give them 90 days to do traffic school. If they can't find the time to do it within 90 days, they come to court and say, I need an extension. Well, I understand that. If you have any legal reason why you didn't do it in 90 days, if you suffer a horrible disease or something tragic, okay, no problem, we'll give you an extension. But if it's just that kind of escaped my mind, just forgot, anyway, I have busy life, I'll give them a 2-week extension and charge them $50 in court costs. Now, that's something that I do. I don't think other commissioners have been doing that. But to me, it makes no sense that these folks get a free continuance. They have to put the case back on calendar, it takes court time, it takes our time, they're not in compliance, and frankly, I've been doing it, I've never had any blowback from anybody say, well, that's not fair. You know, $50 for an extension, and a 2-week extension, not, you know, another 90 days. So, but that's me, and that's nothing required. It's, you can always exercise your discretion to do that kind of thing. Okay, traffic school going over 90 miles an hour. The presumption, the default is no traffic school if you go over 90 up to 100 miles an hour. It's discretionary. People on the toll roads, circumstances, I look at the circumstances and I look at the person's driving record. If they got a good driving record and they're on the toll road at, you know, at low time, low peak time, low traffic time, I'll give traffic school for going 92, 93, 95 maybe. But that's a call that you can make. It's within your discretion. Obviously the fine is 100 plus penalties, but I think it's okay to do that. So people may ask you for that, and that's an option I think is good. Now there's a diversion option on page 11. All right. Oh, one other thing about traffic school. People have come in and asked for second level traffic school. They used to do that. About 10 years ago, they stopped doing that. Second level traffic school was if you've been to traffic school and you got another ticket and you don't want it on your record. So judges used to do a couple of things. They used to have people donate blood. And go to the Red Cross, show me proof that you donated a blood. Remember in Central Court, well, they used to give blood for everything in Central Court. But then we got people having other people go to get blood. They come in with fake certificates. And then the Red Cross said, hey, we don't want people showing up to get to beat their traffic ticket because then they won't disclose the true, you know, medical history that they have. And so anyway, so they put a stop to that. But then they started doing second level traffic school, which basically means do the traffic school twice. And then some of the traffic school providers decided to charge double and do a second traffic school. So it was a dismissal under 1385, you know, just quote, interest of justice. But again, that defeated the whole idea of accountability for your traffic habits. And they banned that about 10 years ago. It was all over the state, everybody was doing it. And they finally said, no, we will not recognize any second level traffic. But people still remember that. And so they'll ask for that. You know, hey, my buddy got it. Yeah, well, it's over with. Sorry, cannot do it again anymore. So you do have the discretion to give them traffic school, and you can extend traffic school for higher mileage, but you can't do it if they've been to traffic school before. It won't do any good. It will not reflect on your driving record. Also, something that I didn't know until I started doing this for a while. If they owe money on a case, if they're making monthly payments on a case involving traffic school, because we allow monthly payments on traffic school, we receive the traffic school certificate within a timely fashion within 90 days. We hold on to that. We don't report it to Sacramento until the entire ticket's been paid. So sometimes people will have it on their record and say, well, I thought I went to traffic school. I say, yeah, but you didn't finish paying the ticket. Yes?
Correct me if I'm wrong, but I'm thinking that they could make payments on their bail. Can they?
On bail, yeah.
Yeah,
But
and then
that's
they
on the
can't
bail
get their
forfeiture.
trial,
What?
and then they wouldn't get their trial until they paid off the bail amount, no?
No, that bail forfeiture is different. If somebody can choose to forfeit bail, which means pay the fine, you're not entering a plea technically, there's no guilty plea, it's just bail forfeiture. It counts as a point on your driving record, and it's immediately reported, immediately. And then they just continue making their payments. So, okay? We also have a child safety seat. Did I talk about that? All right, now there is, when you've got these child safety seats where kids are in a wrong kind of seat. They have to be either turned around when they're very young, other way with booster seats until they're 8 years old or 80 pounds, whatever it is. You get those kinds of violations. Now, they can do traffic school on that, and it can be taken off your record. But the county here does offer a child safety seat program, which costs $50. And as a result, it's a total diversion. It gets dismissed. And otherwise, the tickets are like $500. And oftentimes, you got young families, and those tickets are pretty darn significant. And so they've had this program. Basically, as I understand it, I haven't been to it, but the program shows you movies of what can happen to little kids that aren't properly seat belted, and that it's shocking enough that it's supposed to remind you that not do it again. So I make that offer. I offer that and make that available. It's not typically on the website or anything like that. So it's really better than traffic school. There's a tobacco class. They don't cite people for tobacco all that much anymore. Now they don't have to do marijuana tickets, but if you're between 18 and 21, it's still unlawful to use marijuana. So they have the alcohol drug awareness programs. $50 to the court, you complete it in 90 days. And it's done at one of the city colleges, Santa Ana City College, or I think it's Orange Coast. Anyway, so they have those as alternative type of disposition programs.
What's tobacco?
What's that?
What's the tobacco?
Yeah, what is a tobacco violation?
When you're under 18, well, we have juvenile tickets, when you're under 18. And for those kinds of violations, they go to a tobacco awareness class. And we also have helmet classes, but I shouldn't say helmet classes. Helmet violations, when you're under 18 and you're not wearing your bicycle helmet, is dangerous. But the code provides that if it's your first offense, that the court shall give a warning. So I always shake my finger and say, don't forget, some people have them write essays, and I'm bringing that up because I'm going to beg you, please don't have people write essays. Right now. Essays are just nothing but the start of a painful process, because either we've had them, for the helmet classes, or even tobacco classes. Why is tobacco not good for you? And I've had some commissioners ask that kind of thing. If the kids don't know, copying it off the internet's not going to teach it to them. You can do whatever you want, but if any pro tems order essays, you've got to be responsible for reading them, evaluating them, following up, and doing whatever it is you want. But you shouldn't be dismissing cases for that kind of thing. All right, where are we? Let me see this. Oh, a couple of other strategies for efficiency. Okay, don't say were you insured on the day of the violation. Why not? Because then you get an answer that we don't care about. What do I ask? I say, do you have evidence that you were insured on the day of the violation? The answer to that's either yes or no. So I try to, cut off conversations. If people have multiple cases, and sometimes you'll click on ELF. I had one kid, 9 tickets pending over the last 6 months. 9! Driving a loud BMW. And they kept exhaust tickets, muffler tickets, speeding tickets. And guess who didn't show up to court? He didn't show up to court. That's an occasion where I issued a warrant for his arrest. So he's got 2 warrants out. The other ones were all failures to comply, failures to pay. He had paid absolutely, Lindsay, he had paid 0 on all those tickets, right?
Correct.
But that's rare. We don't see too many people that do that. So the multiple cases, I put them at the end of the calendar. So if somebody comes up and it's going to take 10 minutes to deal with them, tell them to have a seat, we'll get to the end. Anything that's really complicated, put that at the end of the calendar. I also call up groups. I call up, the first person I call stand at the front. I don't think it's, appropriate to have a lineup of everybody standing there. It's not, it's not Kmart. It's, but I have them sit in the front row and then call them up one at a time. okay? And I think that's a fair way to do it, so I call it groups. And then I've got down here something about an express option, which I've stopped doing, but if it's, you have a very, very busy calendar day, 110, 120 people, and you need to get out of there. I've done it where I have people that only want to plead guilty or be referred to traffic school. No trial settings, no proofs of completion, nothing else. If they're that simple and that quick. The problem is, although we can go on ELF in any order that we want, it's harder for the clerks to do that. And it takes a bit of organization for the clerks to pull out cases as they're coming up. So I don't do that very often at all anymore. It was only because we had, for a while, we were having arraignments one week and trials another week. Then we did no,
It was,
So-
we didn't have civil assessment calendar.
oh, we didn't
so
have
it's
civil
easier.
assessment calendar. Everything was over at North Court for civil assessments. So anyway, we got very heavy there for a while, and that was just an efficient way to do it. All right, let's see. All right, here I am with the ELF demonstration. Let's, I need to switch over to that and explain to you what that is, and then after that, we'll take a break. Okay?
I have a question for you.
Sure.
We got an
Come on
email
up here, you can
today.
get these.
We got an email today about a training at CJC for ELF. That's Friday
Oh.
at whatever, 2:30 to 4, something like that.
Okay,
And so, and
Well-
they gave us 2 options. I'm wondering if,
This will take the place of
I
that.
don't know. You know what? Do you know, Gina?
I don't know for sure because I didn't really know that you were doing ELF.
let me look at the
Well,
email.
when I was, I did it, I've done it the last couple times, or the last time we had it. And on ELF, do you know, Evan?
Can I add something?
Sure.
When I took ELF, I decided after 31 years of doing pro tem, I wasn't gonna do it. It just looked too confusing to me.
And then?
And then I started using it. It's really simple.
Yep, totally, totally. Everybody was resistant when they first invented this. Do away with our paper? Oh my God, you know, I mean, those of us that have got a little gray hair realize, you know. All right, and I'll take a couple more questions, then we'll take a quick break. Yes, sir.
Sometimes got people throwing some light cigarette or something. out the door.
Littering violation.
Yes, the fine is very severe, plus 8-hour community service. Some say, sometimes insist on, I don't have time, they cannot pay.
Yeah.
I feel like, it's not fair for people who can't pay or can't pay, so.
What I
do you
do,
think of that?
what I do, I read that as the statute requires upon conviction that you pay a fine, 100 plus penalties, which is about $500, and do 8 hours of litter pickup. I offer people at arraignment the option to do both, or excuse me, yeah, to do either one or the other at arraignment. But I say after trial, then there'll be a conviction. See, conviction is not the same as plea. Okay, if you plead guilty, that's different than being convicted. You can call it a stretch, but I can get away, no one's ever criticized me for doing it, or at least not to my face. But I believe that the intent is to let somebody do just that, pay the fine, or do 8 hours. Because some people would so much rather do 8 hours of litter pickup, and some people would so much rather pay the fine. And, let them do what they want to do at this point. They're showing their penance for the violence. And by the way, littering is ashing a glowing substance or trash, a cigarette or trash paper or anything like that. So it is supposed to be a glowing substance. If you ash a dead ash into the air, there's a case that says that that's not littering. And a lot of us for a while were, anything came out of the car. But if the officer says it was glowing, it's a violation. If it wasn't glowing and it's just ashes, then that's not going to, you take care of the cigarette, then it is. And it may be a violation under another code section, but it's not the goal.
On that point, but then I had another question for you. On that point, I had a case, and there was an attorney. And so I went to the code to read it. And the officer said he didn't know if it was glowing or not. Well, they changed it, it has to be glowing.
Exactly.
Then later, the attorney saw me in court and told me that was his daughter, and I told her not to kill me. But the question I have for
Should
you.
quit smoking.
Yeah, that's
Okay.
another question. Actually, she was 30 or so.
Still she
The
quit
other
smoking.
question I have for you is we get a lot of officers who the person will go up to them and say, I'm a truck driver, can you reduce it to a non-point?
We can get into that. Since you brought it up, I'll bring it up right now.
Okay, but let me, if I may, we got a memo from the presiding judge saying an attorney can't talk to the officer because the officer's not an attorney, but the person can. I don't agree with
No,
that.
that's not what that memo said. The memo said that it's inappropriate for a commissioner or a judge to amend a violation on his own motion. Okay, that's what that said. And it said that officers, police officers, are not attorneys. They have no standing with the court. They cannot make motions, okay? They are only witnesses. However, a witness can describe an action that they believe is more appropriate, in my opinion. They were the ones that were at the scene. They are the ones that made the observations. And if they think disobedience of a sign is a more appropriate violation than disobeying a traffic control sign, I allow those types of amendments. I won't make the amendment. It has to be the officer. So most officers will not do that. But to me, it depends on what the facts are. Totally facts driven. And I don't know, maybe the officer has a problem with the case. Maybe the officer left a speed survey at home. Maybe the officer says, for whatever reason, he's the one that's making the call. And if he says, Judge, I think this should be a 38-300, if that's what he says, that's fine.
In Westminster, they almost all do that.
Yeah, I know they do. But that's, well, let me call it, I think it's next.
LA Superior Court Appellate Division, People versus Simpson,
Yes.
a couple of years ago. Very well-reasoned case that holds that the court does not have the power to amend a citation. Only a prosecuting attorney can do it.
Right.
Separation
And
of powers issue.
I don't disagree with that. Yes.
What about the issue when the judge amend the speed to allow to do the traffic school?
Yes. Well, you don't have to actually amend the speed. You can just allow them to do traffic school. You can't amend under 100 miles an hour. However, if you find that the violation, that you have proof beyond a reasonable doubt that the violation was over 65 miles an hour, but not over 100, I have done that. I have found them guilty of 2249 over 65, rather than on a speed of 101, 103, 105 maybe even. I don't know what the testimony is. I don't, depends. Is it a radar ticket? Is it a pacing ticket? And all the other circumstances. But I do find people guilty of a lesser included, which is what that is. Yes?
So just following up on what was asked, so truck drivers, they lose their livelihood to work, and it's quite burdensome.
I know, but
So I know we can't. So now I think in LA what we're doing, we're asking them if they would talk, or we tell the relevant parties not to talk together outside. So before they come in, so if they can reach an agreement. So basically the defendant speaks with the police officer, so the
well,
judge doesn't
that's
get
fine.
involved.
In my opinion, that's not a problem. But let me just tell you why. I was on the Traffic Advisory Committee of the Judicial Council when I was a lawyer. So it's been like 15 years now. And traffic school was being offered for commercial drivers. And commercial drivers who are controlled by Interstate Commerce, federal agency, were getting tickets and doing traffic school, arguably all over the country. They could have 50 tickets, well, maybe 48 tickets. They could have a ticket in every jurisdiction. They go to traffic school in every jurisdiction. And their driving habits would not be reflected properly in their records. The federal agency said, look, we're cutting off funds to California to continue to allow to mask convictions And so then they enacted, no more commercial drivers can do traffic school. A number of years went by and they said, well, what if they're just driving their own car? Okay, they can do traffic school if they're using a non-commercial vehicle. And that's the status of the case now. But I've seen quite a few cases where truck drivers are getting ticket after ticket after ticket, and I look at them and, oh my gosh, coasting, not obeying a sign, coasting, you know they're all speed tickets. You know, to me, I don't know that I want that truck driver out there on the road. To me, I feel that you have a responsibility to the Department of Motor Vehicles to accurately report the driver habits, not feel sorry for every truck driver. And I do empathize with many people in that situation, because yeah, they are driving for a living, but you know what, they're driving these, you know, huge trucks that can kill people, and I don't want to drive them inappropriately. One more question, and then we need to take a quick break, right?
So sometimes then, if a police officer reaches an agreement, you'll refuse to accept it in
Never.
that situation?
No.
We will accept it.
No, I said, that's what I said. If the officer amends,
Good point.
yeah, because the officer's the one that cited in the first place. No, I'm happy. I do give trust to what the police officers want to do. And sometimes they do it to be expeditious, and sometimes they do it for equity, and sometimes I don't know why they do it, but they do.
Oh,
Yeah.
I'm not asking him.
Well, should we just I think we should take a break. I'd be happy to talk to you. 10-minute break, okay? Let's start up again at 5. And then we have another hour. I mean, people do things differently. And, I mean, I'm comfortable with the way that I do it. Apparently at Westport, things are done differently. Northport's a little different. But I'm comfortable with the way I like it. And by the way,
Is there still night court?
What's
Is there
that?
still night court for traffic?
Night court once a month. Once a month at all the different justice centers. But usually pro tems aren't doing it. Are they?
Yes, they are.
Oh, you are? No, they're not doing it here. Most of the time, it's because the judges rotate. That's like their only chance, opportunity to act like a real judge. Excuse me, act like a real commissioner. No, so they get to. I call it commissioner appreciation time, because they always come back and say, Max, how do you do that all day long? These people have so many questions. Anyway, so. But I really do like what I'm doing, and I hope that you guys get as much enjoyment and interest out of what you do when you take my spot. I'm glad I've gotten a chance to meet some of you, because I do know your names by the work that you do here, but I didn't always associate your faces. So, all right, this section I'm going to talk about the trials. And when the clerk will do a calendar call first. And they'll determine who's here, who's not here, and so forth. And then they'll separate the cases. Some of you, this is repetitious, but it'll tell you which cases have attorneys involved, which ones have officers that are not available, not appearing in court, which ones where the defendant is not appearing in court, which ones neither are appearing in court, and that's how we'll start. Oh, and then they separate the exotic languages and accident cases. And the reason that we do all of those, I think there's good reasons for all of them. First of all, I'll go backwards. Accident cases. Usually, there are civilian witnesses in accident cases because hearsay evidence is not acceptable. It deprives the defendant of his right to confront the witnesses against him. And although they can bring in their accident reconstruction folks, if the information that they provide is based on statements made by the other driver, and the other driver is not here to be subject to cross-examination, then that's hearsay, and I don't allow it in. And one of the things I do want to tell you about this for traffic accident cases, for those of you that have been doing this for a long time, I hope you picked up on this, and if you haven't, try it sometime. Sometimes you'll have maybe 2 or 3 witnesses, 2 or 3 people involved, chain accidents, car hits and hits another one, hits another one, hits another one, whatever. So you got all these people. The officer's done a traffic collision report, and then it's referred to the officer who is authorized under 4000.6 to issue the citation. So the officer that did the report is not the one who is the citing officer. You need both officers in court. Also, you need the witnesses, because, as I said, the officer cannot testify to hearsay unless the witnesses are eligible. And that is not court attire.
Not court attire.
But it's, what are we playing, basketball or baseball?
Basketball game.
Basketball, okay. That's how they stay fit, you know?
Keep our stamina up to keep up with the bench officers.
What I do on a case where there is a traffic collision is I tell the defendant, first introduce all of the witnesses. These are the people that are witnesses against you. And I'm going to ask the officer, or I'm going to ask each of the witnesses to pay attention, to listen to the officer's testimony. I'm going to allow the officer to testify as to what each of them told him. Then I'm going to give each of the witnesses an opportunity to clarify or to modify or to correct any of that testimony. And if they're satisfied with the testimony, then we go to the defendant and he can cross-examine each of the witnesses themselves and, of course, the officers that are involved. Believe me, that saves time. Otherwise, you get a version from witness A, witness B, witness C, and it just takes forever. Any of you have experience with traffic cases that take a long time?
Well, just on that particular one, I thought the policeman was only there to authenticate the business record. And then you need the civilian witnesses in order to provide the direct testimony concerning whether or not a violation occurred.
Well, technically, you're right. But the point is, you can avoid the live testimony by, no, let me put it this way. The objection to hearsay is defeated when the declarant is present in court for cross-examination.
Right.
Okay? So as long as they're here for cross-examination, frankly, I wouldn't do this on a misdemeanor or a felony, but on a traffic case, we can do it, as long as they don't object.
Oh, no, the only reason
I have to ask them first. I say,
The only
if
reason
it's
why
all
I'm
right
asking-
with you, it's more efficient to do it that way. Yes?
Yeah, the only reason why I'm asking is because typically I ask, are there any witnesses? More often than not, in my cases, there are no witnesses.
Right.
So technically you have to dismiss. But more importantly, on the cases that I've had witnesses, I've only had the custodian of record police officer. I've never had the officer who actually wrote out the report. I didn't know that that was a requirement.
I've never had it done on custodian of record testimony at all, ever. The officer that does the report provides the report to the citing officer. The citing officer has to be qualified, trained by there's 3 or 4 classes that they're supposed to take, and then they have authority to issue a citation for an infraction not committed in their presence. Otherwise, nobody has authority to do that. And when you present the case, if somebody gives me a report, sorry, I'm not going to read a report that nobody, And you're also not going to have the witnesses, they're not police officers, they can't present the evidence. Okay, but anyway, so I have the officers give the rendition of the testimony and then allow the defendant, of course, to cross-examine it. Anyway, that works pretty good in most cases. Now, the first thing I do is call cases where officers are not appearing. I do that for a lot of reasons, but there have been some bench officers in the past who say, well, they just got lucky that the cop's not here, I'm going to make them sit through the entire calendar, so they'll learn something. No, that's not, I think, is appropriate. But so you can do it that way if you think it's a good idea. But I just get them out of here as quickly as possible. Officer Smith is not present, and unless there's good cause. I had good cause one time, about 2 years ago. You guys will remember there were people shooting police officers all over the place. It actually started kind of across the street from here in an apartment complex, and I forgot what his name is. That's probably good. But every officer was mobilized. And it happened to be a Thursday, which is Irvine Day. There was no Irvine officer here, but it was an emergency situation. I found good cause. I evaluated each case. I told them why the officers weren't here, if that was, it's not that they were on vacation. I evaluated each case. Sometimes I took, if they wanted traffic school, did that. There was only 1 or 2 cases that I felt needed to be continued. and we trailed them for a week. And then somebody got upset and said that I shouldn't have done that, but then I was upheld, so to speak. Anyway, so if there's an emergency situation, you can find good cause to trail a case. It doesn't happen very often, though. And, well, you don't get involved with it too much, but I get requests for continuances because officers are on vacation. That's not a good cause. Or if they're on training, that's not a good cause. So anyway, so if the officer doesn't appear, the charge gets dismissed. And then somebody asked me a good question about civil assessments. If there's a civil assessment on a case and the officer doesn't appear, and I always advise people of this early on if I know there's civil assessments, so I doesn't feel like I'm picking on somebody. Civil assessments are independent of the citation itself. The civil assessment is a civil case. It is a case that requires a preponderance of the evidence. It doesn't require testimony by a police officer. It only requires that we have a copy of the citation. The citation has a signature. That signature is the same signature as the defendant's signature, and I'm satisfied with that most of the time. Obviously, the defendant may have legal reasons why he wasn't here on time and so forth, and I'll certainly hear that. But just because the officer's not here, I don't dismiss the civil assessments. If the defendant is, if the officer is here and the defendant's posted bail and he's not here, I forfeit the bail. There's no further court appearances, no penalty, no civil assessment, no nothing. Yes, sir?
That last iteration of the civil assessment, that's if it's a failure to appear for the civil assessment.
Yes.
Not the civil assessment associated with payments.
No, the failure, if the person didn't appear and then set the case for trial, and there was a civil assessment, and then they say, well, can I have the civil assessment vacated? And
No, that's the FTA.
Yeah. Okay, so if bail's posted, bail's forfeited, no further proceedings. If the officer's here and no bail's been posted, the defendant is not here, I will look at the docket. I'll see if the defendant was in fact ordered to be present on today's date. I'll look and see if there's a release on his own recognizance, which is additional information, because sometimes they don't sign releases on their own recognizance and the judge just orders them. I prefer having the document, but if the defendant was ordered by another justice center to be here, then in many cases I'll take a trial in absentia. I'll make a finding that the defendant was ordered to be here at 1:30 and right now it's 2:30. We have not heard from the defendant, the officer's been present, we're going to have him proceed. Officer testifies, I listened to the testimony, I found people not guilty based on the officer not presenting the case properly. Most of the time that's not the case, most of the time. And what do I do then? The fine, if it's a speeding ticket, I'll give them a standard fine, $238, but I will add a civil assessment for their failure to appear. I could issue a warrant, and if they have a really bad driving record, maybe I would. But in most cases, I just add the civil assessment. Now, you may say, well, isn't that kind of harsh? So you got the failure to appear, they didn't show up. But my feeling is they promised to appear, the officer's here. Sometimes, people don't show up for whatever reason, who knows what it is. And they come back to court and they say, well, Judge, I didn't show up because I had to work that day, and I know I should have been here, but do you think I could do traffic proof, for example? You know, if it's circumstances that I don't think are aggravated, I'll give them traffic school and I'll vacate the late fee, okay? But if you just take the testimony and they don't show up and then they come with no late fee being imposed, they come in and say, oh, I think I want a trial now. Well, no, we've already had a trial. And there's no incentive, let's put it that way, for them to agree to either pay their fine or offer traffic school. I would offer traffic school in a lot of cases if they fail to appear, if the record is okay. So anyway, that's something that I do. And I will vacate the late fee if there's some appropriate cause. But if not, I don't think they should get a walk. I really don't.
Excuse me, Your Honor.
Yes?
So when you do that and you have a trial and you render the sentence and.
Well, you give them notice, I'm sorry. You give them notice that they are ordered to pay X number of dollars within 30 days by mail.
And then they come in at that time, advance the case to talk to you. Okay.
They can. Sometimes they don't, sometimes they just pay it, because they know that they blew it. But it doesn't preclude traffic school, in my opinion. It's still within our discretion. And you know, then, after I've taken the role, then what I generally do, there may be, you know, half the calendar. It's not unusual for me to have like 30 people on the afternoon calendar. Take the role, all of a sudden it's down to 20 people, okay? Because maybe 10 officers don't show up. And don't ask me which ones do and which ones don't show up. It's different agencies have different rules, but most of the people in South County, they do a pretty good job of showing up. There's some sheriffs that don't show up as much, but anyway. Then I tell people, okay, folks, if your first line of defense was hoping the officer had something better to do today than to take care of your case, that apparently has been defeated. If any of you would like to go home, go on about your business, and send the officer out to give tickets to people that really deserve it, that always gets a bit of a laugh, not from you guys as much. Anyway, I said I'll be happy to take a guilty plea. You can also plead no contest, which means you're not admitting the violation, but it still counts as a point on your driving record, and the fines are the same. And if you qualify, I will reconsider your suitability for traffic school. Always, you know, and I'd say anybody wants to get out. So, you know, usually about, like today, probably about 7 people got up and asked for traffic school. And so I'll look at it, and I will look at the cases. I'll say, look, you know, the officer's here, they're ready to go. The defendant now wants traffic school. I will look to see if they've been to traffic school recently. I'll look to see what their overall driving record. I'll look to see what the circumstances of the case are to a certain extent. I'll look at the citation and I'll ask the officer, how did the stop go? Anything unusual? No, nothing unusual. Do you want traffic school? That'll be the order. Yes?
Remember when you were talking about generally something about like over 90 miles an hour and no traffic school or something? Is that a situation where the DMV could possibly not honor the traffic school if you ordered it in that 90 to 93 or whatever?
No, it doesn't preclude it.
Oh, okay.
It's always discretionary with the court. But the DMV will not do it for cases that are prohibited, but not speeding tickets under, yes, 20-49, yes.
Does there anywhere shows DMV, I mean, traffic school, yes, or do we have to click on DMV to find out ourselves?
Yes, it shows.
Where? I don't see.
It shows underneath on the left side, it's eligible for traffic school. Does it show to the bottom?
Okay. Under vehicle?
Down?
Okay, thank you.
You see it? Yeah, it will show eligible for traffic school. But sometimes it will show eligible for traffic school, and they're actually not because it's just not in the system yet. And sometimes it will show not eligible for traffic school, and they may be eligible, and it would be under circumstances when the case has already been concluded, or maybe there's been a trial by declaration completed. I don't know. So it's not always controlled, but it is on the form. Okay. So we talk to the people and then ask them if they want traffic school. If they don't, then we proceed with trials. And I usually do the accident cases first because they're civilian witnesses. And then I will, you always have to be you need to be sensitive to interpreter cases because the interpreters sometimes are needed elsewhere. But they sometimes take longer too. So they're not necessarily going to get priority. And then we'll, the attorneys, most of the attorneys that practice around here, when they know the officer's here, they'll just ask for traffic school. They'll have trials on some if the people aren't eligible for traffic school, and those go pretty fast. And I guess you kind of have to know who the attorneys are that'll go through it fast, because if there's a bunch of cases, I'll let the attorneys go first. I don't let all the attorneys go first, because there are some attorneys that will make a mountain out of a molehill, and everything is a, and they have a right to do that. They can't go at the beginning, because it'll, well, I've done it once, and everybody else got so frustrated. Yeah, I mean, truly frustrated. Somebody in the audience says, I'll pay his ticket if you stop asking questions. And it was an inexperienced attorney who had an attorney for a client. I shouldn't say inexperienced traffic attorney who had there was a PI attorney for a client. And he went on and on and on. Questions that I couldn't object to, but also questions that didn't really make an awful lot of difference, and it just frustrated. So that's one way to get people to plead guilty too, is bore them to death. But I usually don't do that. I, let the attorneys that'll go through the cases quickly, because they really don't ask a lot of questions. Most of the traffic clinic type cases, there's 2 or 3 clinics that have a lot of cases, which is fine with me. All right. I do give priority to, where am I? I've got something going on here. I'm not good at this stuff, sorry. 18. One more. Okay, there. Civilian witnesses, I give them priority. Sorry about this. Anybody with young children, I give that priority. And I do that in the mornings too at arraignments. If I see, if I'm able to see somebody with a little kid, and I say, I usually tell people, I say, I'll give people priority to have young children. If you think it's a good idea to bring your young child, that's fine. Just understand you have to take the little one with you, and that's a lot of work sometimes. Anyway, so I do give them priority.
Do you have them wait outside till you call their case?
Oh, only if they're making noise, but I usually just get them out of here as quickly as I can. In fact, I'll even do it before I give them the admonishment, the advisement, I should say. Then interpreter cases, and then call officers with single cases before multiple cases. You'll have a list of which officers have how many cases. So get the officers out of here with just 1 case at a time, quicker than the ones that have like 6 cases. And let me tell you something about officers with multiple cases. Sometimes you'll have an officer that has like 3 or 4 speeding tickets. If I see that, I will call all 4 of the defendants with those tickets and say, folks, will you have a seat in the front row? I want you to listen to the officer's training, experience, and any credentials he may have earned, because the same information applies on each of your cases. I'm going to ask that you stipulate that his testimony on this case should be as if it was on your case. You, of course, can cross-examine him on all of the issues that he testifies to, but as long as, because it's how long he's been there, when he did his post-training, some other things about his background. So it's just more efficient to do it, and usually everybody agrees to do it that way. It does require an agreement, but almost everybody does, otherwise it gets even more tedious. And that's especially true on photo enforcement tickets if you do those at West Court. Anyway. All right, I think we talked about if he fails to appear at trial already, and that's it. If the officer fails, then
When you calculate the bail, do you include the penalty assessment?
Yes. Okay, I'm going faster than Okay, yeah, I have people that sometimes request a reduced fine. I don't know if you reduce my fine. I think we went over this. I'm not going to do that. I sometimes tell people it's not a swap meet here. We try to be fair, we try to be consistent. Same violation gets with the same record gets the same fine. And that's that. All right, and we talked about amending the citations. And why. Discovery issues. Okay. This is a big thing. Some people read the internet and they file discovery motions and all of this kind of thing. And discovery is important. You have a right to have discovery. But what is it that can be discovered? Public information is not something that's discoverable. You can get, for example, you can get a speed survey as a matter of public record. There's no obligation for the police department to get speed surveys. You have a right to a copy of any documents that are going to be used at trial, but that's all. You don't have a right to the training manual, the training records of the police officers, personnel records of the police officers. You get the most absurd requests. How many tickets were written on that day at that time? And it goes on and on and on. And when the police departments ignore it, obviously, then some people come in with motions to dismiss. Well, the options for a discovery violation is that they can file a motion to compel discovery. And the penalties, if, first of all, if the motion is well taken, then first you should give an opportunity for the police department to comply. You also may grant a continuance for the defense if they need more time to prepare. The last thing you do, and there is no real option for dismissing, is to dismiss a violation because there's been non-compliance. If you make an order that the police department complied with something, then their remedy is to quash the order or state objections. Now, here's the problem, because this brings up the whole issue of the prosecutor involved. For those of you that are new to this, there's no district attorney that will show up in here. They are not required to show up in here. They have prioritized, and really it's in the government code. No district attorney has to participate in a traffic trial or traffic school operations. It would be nice if they would. I wish they would. And I've called them in, and on occasion they have participated. But that's very, very rare. And so the defense is always required to serve the people, and the people take those, and I'm not exactly sure where they deposit them, but they're nowhere to be found. Right? Ex-district attorneys, where are you? Right? They just don't participate, and they're not required to. So that means it's up to us to kind of wear both hats. And is that permissible? Yes. The Carlucci case says that. And I cited that in here. And what it basically says is you've got to try to be fair to both sides, and that means you've got to look out the rights of both sides. And that includes the prosecution. You can't become a prosecutor, and you can't become a defense attorney. And when you've got a pro per defendant and a police officer in front of you, sometimes it's extremely, it takes extreme bit of skill to not decide one side or the other, especially since you're all practicing attorneys. I remember one of the early trials that I had after I became a commissioner. I objected. That's not my role. I'm supposed to sustain, or didn't I? But I said objection. Then I caught myself and said, wait a minute. Anyway, your role is not, obviously, to be a partisan for one or the other. And you need to not only be fair, but you have to give the appearance of fairness on both sides. So that means you got to just try to cut it right down the middle if you possibly can. Yes.
How about prompting the rehabilitation of the officer's testimony? Like a new officer who misses and he was in uniform, like that.
Again, you've got to try to be fair. You've got to try to be consistent. If it's a 120-mile-an-hour citation and you forgot to say what he was wearing that day, I might just say, how were you attired? And if he says, well, I wasn't that tired. Believe me, there's some that are clueless. They really are. And the funny thing is, I was just going to get to that. You know, there's certain things that you have to establish as part of the prosecution. It's real easy if you're a DA asking questions. You can say, what county did this happen in, or where? Then you got jurisdiction. And sometimes I will say, only on really serious cases, and maybe that's tipping the scales of justice a little bit. But if the case is bad enough, I might just say, I would ask the officer, do I have jurisdiction over this case? He says, And if he says, well, yes, Your Honor, it happened in the city of Costa Mesa, County of Orange, that's obviously the right answer. I've had people, I had one officer say it happened in, it happened in Newport Beach, state of California. And then I said, what did you say? Newport Beach, state of California. Newport Beach, state of California. Okay, that's where it happened? That's where it happened? Okay, very, I dumped it. I mean, how hard is it to say County of Orange? I don't have statewide jurisdiction. I have jurisdiction only in the County of Orange. And just like on a pleading, if you don't plead that the court has jurisdiction, you're out of court. They know that. They learn that in, police school.
You're saying in most, all cases, if they don't say that, you dismiss the case?
Yeah.
Wouldn't you take judicial notice that Newport Beach is in?
You know what? If I were living in Newport Beach, I would know very well where it is. It's not something you think. Judicial notice is not just something that I know. Okay, that's a word of art.
It's something common, that's something subject to ready
And
assertion.
that may be the case, but when you're dealing with a legal case, one of the elements of the violation is that you have to establish jurisdiction over it. And it's not to say that Newport Beach might be in some other kind of state. No, it's just what has to be done, yes.
Motion to reopen?
Nope. I deny it. I mean, then I think you are leaning too far over. Yes,
Would it be easier to just ask which county this occurred and then let them say it?
I could, but then, how about this? Officer, were you on duty on such and such a date in the city of Santa Ana in the county of Orange? And were you wearing a blue uniform? And did you observe this car go through a stop sign that was octagonal and there was a red line behind it? Is that what happened? Yes, Your Honor. Okay, guilty. Really? No, but that kind of thing, see, that doesn't give you the appearance of fairness. Yes.
Do they have to bring any
Lori?
surveys?
Lori, I haven't got this.
What's your position on demurs, especially on the
Oh,
failure to obey a sign when the citation doesn't specifically say what it was that they didn't follow?
Yeah, that one's kind of fact-driven. I get a lot of demurs, and I'm not sure that many of you get the demurs at Arraignment. Have they been serving it on pro tems?
Yes.
Have they been? Okay. There are several that are fashionable now. Now, when you receive an electronic citation, okay, that's the new thing, what 4 or 5 years old? The electronic citations have a place where the officer signs it as a declaration. I declare that the foregoing is true and correct under penalty of perjury, and there's no little box with the date on it next to it. So they said a electronic citation is lawfully used in lieu of a verified complaint. Verified complaint is what's required for criminal prosecution. But if you have a properly signed citation, that can be used in lieu of the verified complaint. So one of the things that have been objected to is that the officers who signed it, they don't put a date on it. Well, there's a date on the top of the citation. And when those were presented to me, I said, well, look, I can take judicial notice. The officer signed it on the same date. I know what that date says. I know what that date belongs. It's not there, but that's surplusage. I really don't care. Anyway, that actually went up to the appellate department, and they said I was wrong. If you don't have a date on a verification, it's lacking. You have to write verification on declarations, whatever. The date, the signature, and the location of where it was signed. So now, what's the consequence? The consequence is I order a verified complaint. Well, who do I order the verified complaint to?
Yeah.
The district attorney. Hello, district attorney. I'm going to order this case dismissed if you don't file the verified complaint within 10 days. Do they?
No.
Not very often. Very, very, very rarely. So you talk about selective prosecution? That would be the next step, is why are you filing a verified complaint on this when you don't on any others? But anyway, so I was told I was wrong on that one. Then there's a second one, and that is that on the bottom where the officer, no, the defendant signs the citation acknowledging that he received the citation. The officer gives the defendant a copy of that citation without a copy of the defendant's signature on it. The court gets the sign, because it's electronic, okay? So the court gets the signed copy from the officer and signed by the defendant. And the officer is now putting the date on it because there's a blank that automatically tells the officer to put the date, or that it actually generates the date. Anyway, did some software thing to fix the first. Now the second thing is this. Objection, verified complaint required because the citation that the defendant received is not an exact copy of what the court received. What's lacking? His signature. My argument was it doesn't need his signature unless there's an issue that he was given notice to appear, and he's here. You're here. You know, it's always an attorney. You're here. You know he was supposed to be here. He knows he was supposed to be here. Yeah, but it's not an exact copy of what the site of what it is. So we want to we want to dismiss it. But if you don't dismiss it, give us a verified complaint. So at first I was granting those because it's the same theory as the other. That's got to be an exact copy and strict compliance and all of that. And then somebody sent the case up to county council. The county council, who was representing the sheriff's department, they looked closely at the code, and sure enough, about a year ago, there was an amendment to the code that said if an electronic citation is being issued, an unsigned copy is just as if it was a verified complaint, unless the defendant requests a signed copy. It makes total sense. So now that's no longer being, well, I shouldn't say that. My rulings and at least my rulings, and I think Van Camp had some of the same. So we'll see if they're going to take that up now too, saying that that's unconstitutional. And they're saying that it's illegal. I don't know if any of you read the brief, but Bayless and Ball put a brief together saying that that doesn't apply to, that it applies only to the vehicle code. It doesn't apply to the penal code. The penal code is the one that allows verified complaints with electronic citations. And to me, it's kind of a stretch of logic. It made no sense, but that doesn't mean that the appellate department won't disagree with me. Yes.
Obviously, these demurs have to be in writing.
Oh, absolutely. And they have to be filed before an appearance.
Correct,
I mean,
okay.
on the date of the appearance.
Sorry, that's what I was.
Because you can't make a general appearance and not file the demur. So, yes.
Not
And
like
it
on
has to be
television where
heard.
they can bring something like that
And
up.
it has to be heard at or near the time. So
Right.
you can take it under submission, which I usually do, but I usually rule on it the same day. They're not all that complicated. After you've read the first one, they're all in a bit of a pattern. So demurs are something that we get pretty frequently. Something else?
Okay.
Yes.
What if they appear on the first appearance and say that I'm not making a general appearance, require continuance to file a demur, just got an attorney, and this is for the purpose of.
You can file a special appearance.
Yeah,
You
so
know,
then there's
for
no-
exactly what you're saying, yeah.
Okay.
I wouldn't deprive them of the opportunity to file a bogus demur. But all right. Now, so we're on trial day. I advised the people, whole trial process, officer goes first, presents proof, defendant they cross-examine based upon, and I tell them what cross-examination is. Cross-examination is ask questions that are relevant to these proceedings. I've had people start cross-examining on how old are you, where were you born, what college did you go to? I mean, people don't know, and they're kind of doing it because they just don't know any better. So that's why I always tell them up front, cross-examination is to ask questions that's relevant to this particular proceeding. And then you say you have a right to testify, but you're not required to do so. After that, you may give a brief closing argument. And after that, if you disagree with my ruling, you do have 30 days time in which to file an appeal. That's pretty much the procedure, and then everybody goes from there.
Question. You ever had a police officer question the defendant?
Never.
And you never either, right?
Oh, a police officer is a witness. I've had I've had police officers try, and that's not their job at all. Nope. And most of them know it. And I also don't let them intimidate the witnesses. There's a couple of officers that'll stand there, in a threatening manner. Relax, folks, And then the other thing is, a lot of times, the defendant will walk up and shake hands. I said, he wants to shake hands with the officer. And the officer usually will respond with that. But I said, folks, this is not, this is a fact finding, it's a trial. We're here to hear evidence, so it's not a contest. And so kind of.
What's your position on an officer who is in fact an attorney, but has not been appointed as a deputy city or district attorney?
Yes, then he's got no standing in the case.
Done just a witness.
He's just a witness. Does that come up?
That's the ruling I made.
Oh, well, you were right, because I said so. That's good. Okay. Controlling the case is what my next section is. And that is, you don't have contempt powers. Don't even think of calling someone in contempt. As a judge pro tem, as a commissioner, I have limited contempt powers, but only if you have an issue that would call for contempt, you need to call a judge. And the only contempt I can even imagine is an incident that may happen in the courtroom, and then it's a lot more than contempt, and the bailiff will take care of it. Don't get involved with the sovereigns and constitutionalists. You all know what a sovereign is. I mean, these are folks that have very strong commitment to the fact that that we, the state, has no right to control their licensing, their registration of their cars, their driver's licenses, because they have a constitutional right to travel, and nobody can abridge that right. And anyway, they go on and on and on, and they love to challenge you. And what I do the best I can is be respectful and say, I understand that you're objecting to these proceedings. I'll set your case for trial. You cannot set the case for trial because I haven't pled not guilty. Understand? But I'm going to find that you're not able to or willing to enter a guilty plea or a not guilty plea. So I will deem that it's a not guilty. You're ordered to be present in court on such and such a date. And see, they'll stand behind the bar here, and they will refuse to step forward because they refuse to come aboard the ship. The ship is what it is, I guess. The ship of justice. And then they see the flag over there. They see the fringes on the flag. That's not an American flag. And I mean, there's a lot of stuff. And it would almost be humorous if they weren't so dangerous. There's some crazy people out there. And anyway, and there's some people that read about it and they think it'd be a good way to fight the ticket. And the first thing I kind of do is diffuse it. Like they say all the words that sovereigns say, and I say, well, sir, no. Oh, here's one. John Smith. I said, are you John Smith? Well, I am not John Smith. John Smith died 7 years ago, and I am John Smith with a lowercase letter, and I am not John Smith. Okay. So well, next time you see John Smith, tell him he's ordered to be in court. I mean, and then this guy was charged with some violation, and I said, I understand what you're trying to do, but I see you have a driver's license. How can you have a driver's license and profess that we have no right? Anyway, I said, it looks like you've already submitted to the authority of the state. And anyway, some of them will understand a little bit of humor, and some of them don't even bother. It's probably a good idea not to bother.
How often do you see someone like that in your courtroom?
Oh, well, probably not more than a couple times a month. But it's that. No, it's like that. They're
enough to cause delay.
Oh, that's what they want to do is delay and obstruct, and they kind of try to go right at the edge. I mean, if you have nothing better to go online sometime just put their name and put a sovereign, and they have courtroom scenes where, let the record reflect that the judge has abandoned the bench, and now I am in charge, or something. Yes,
I actually sit in traffic case in Los Angeles County.
Yes.
And there are people use this ground for demur. Do you deny the demur first?
what ground? That the court has no jurisdiction?
No jurisdiction, and they are not supposed to decide it, it's not sufficient, the data is not good enough.
You know what? If there's something that you can rule on, you can deny it.
Just deny it.
Just
and
deny
then
it. Don't argue with them.
right?
Say, I just, thank you for your, yeah, your motion is denied. Your demur is overruled. Thank you, and we'll proceed. Yeah, because they want rulings.
Right.
Don't be afraid to give them a ruling. It's okay to say no. They're refused. All right. Okay, yeah, let them make the record. Did I got that? Okay. Don't apologize, I mean, I don't, all right. Carlucci, I talked about that case already. That gives us authority to do stuff. And we can ask questions of the witness, it must be fair questions, and we can use it to develop evidence. We have a lot of latitude. Okay. All right, what's required at trial? You've got to establish jurisdiction, the date, the time, the location. Sometimes they don't give you the year that it happened. You know, there's a statute of limitations. It's got to be within 1 year. The citation has to be issued. Not that the trial has to be had within 1 year. Many certainly are not. That he's on duty, that he's in a uniform. And then don't forget the elements of the violation. Elements of the violation, for example, on a lane change violation, the defendant made a lane change without signaling. I saw no signal. Anything else, officer? No? Made a lane change? Yep, no. So I didn't even let the case go on. What's missing? The element of safety. You can make a lane change without signaling as long as it's done in a safe manner. I had an officer citing 22107 is failing to signal. 22108 says if you signal, it's got to be more than X number of seconds or clicks or something. And so there was this young lady that the officer had cited. It was at a high school. And he had cited her, no, excuse me, he had stopped her a week before for speeding, and she had an underage kid in the car with her, and he gave her a warning and told her not to do it. She said, okay. A week later, he sees her again, and she's in the left turn lane of the school. Left turn arrow, dedicated left turn lane, without her signal going. He pulls her over and checks the person in the car with her, and sure enough. So he gave her a ticket for illegal left turn. And I said, no. I said, it's in a dedicated left turn. How does that affect anybody's safety? He said, well, if you read 22108, that tells you that you have to signal for such and such period of time. And I said, well, that's not a charging section. Okay? The section that sometimes the officers get a little bit too creative. And he goes, well, I didn't understand that. I said, well, if you want to look it up. And I said, if I'm wrong, you come back and tell me. He called me the next day and apologized. I said, no. He said, you're right. It's not a charging section. So anyway, the elements of the violation have to be there. And guess what else? Don't forget, they have to identify the defendant. Now, there I am a little bit more generous. If the defendant is standing there and the officer keeps looking at him and talking about him and didn't say, and the defendant was identified by his California driver's license, and he's the person standing in, next to me. That's the way it should be done. If he doesn't say that, I'll say, I can tell by the way that you gesture that you're talking about the person next to you. But this is an electronically recorded record, and there's no evidence that you have identified the defendant. Is that what you meant to imply to me? And obviously, yeah. So, maybe you wouldn't do it that way. I mean, I generally will do it. Kind of depends on stuff. I've had it, excuse me, one thing. I've had it where it was a relatively old ticket. And the officer intentionally didn't say that that was the person. And I said, are you not able to identify him? And he goes, Your Honor, I have no idea if this is the same person or not. It's been 2 years or whatever it is. And then I did say this, well, who did you give the citation to? And he had a name, and did you look at the photograph on the license at the time? Yes, and, you know, there was enough circumstantial evidence, but that's why, in that case, he didn't identify him, because he couldn't. He should have gone into that on his own, but he didn't. Yes?
And you may have answered it in the most recent comments, but how do you deal with the identification issue in the trial of absentia?
The trial in absentia?
Yeah.
Well, you've got a signed document from the defendant saying that he was, you know, he agreed to be in court on a particular date certain. So the defendant, you know, the testimony of the officer is, the person identified himself as John Smith, and he looked like John Smith from the driver's license. But sometimes we do get identification issues in court, at arraignment also. And sometimes people will look at, you know, signatures, you're going to try to compare, they'll say, okay, sign your name 5 times, and then compare that to what the signature is here. And I'm reluctant to do that. I've done it on occasion, but I really say, well, you know, if you're not the person. Now, if they show me identity theft, show me documents that they've reported, that their wallet's been stolen or whatever it is, yeah, of course I'll dump it. But sometimes we get it where, you know, it's somebody's sister or brother that's impersonating each other. I usually would say, well, set up for trial and talk to the officer. And sometimes people very blatantly stand up there and lie. We better not.
How do you deal with the completely unrecognizable photograph on a photo enforcement case?
Just ask me about photo enforcement cases. They used to come here. They stopped coming here.
They're still going.
Let me tell you what the worst thing about it is I get people in my court every day, because they can be arraigned in any court, and I see it's a photo enforcement ticket. First, with a civil assessment, of course. Well, first of all, I look, there's no signature on that citation. It's a declaration by an officer based upon photographic evidence. That's what it says on that form. And then they issue a civil assessment on that, $350. And what's that? And what's the defendant have to? The defendant. What's the named person have to do? He's got to take off from work. He's got to come to court. And am I going to dismiss it? I can't dismiss it. I mean, I'm not the prosecutor, and I can. Sometimes I'll come in with a picture. You know, there's little old Granny behind the wheel, and he's a, you know, 6 foot tall man, and there's no way it's the same person, but somebody's accusing him. And I sure would love somebody someday to say, look, you're costing me a whole heck of a lot of time and so on and so forth. And then they say, well, just tell us who it was. No, you don't. No, you don't. Anyway, I don't like those tickets. I have had officers testify under penalty of perjury that they reviewed the document, would not issue a citation unless a photograph of the defendant matched the driver's license. They lied. They absolutely lied. Fortunately, I don't want to say good cop, bad cop, but an officer with integrity came to court and said, we were told just to issue it to the registered owners. We did not compare the photographs. I said, is that the way it's always been done? He says, I don't know if it's always been done that way. That's the way I was told to do it, and I had to follow my orders. I said, you realize that you're signing under penalty of perjury, that you did something that you didn't do? He goes, Your Honor, that is the way it's done. And you know what? That is the way it's done, and I wish they'd just change the whole system. And anyway, I've talked to commissioners about doing that. I don't want to go there and do it, but it's not a good system. And you know, the first line is the $225, say nothing of the violation of something that they didn't do. And then we talk about clarity, because I dealt with those in North Court. We had photo enforcements, and sometimes it was not a clear picture. Sometimes it was a really fuzzy picture. This one guy in particular, I will never forget. He was in court, and his face was fuzzy, but he had gray hair, and the guy was gray and all that. And he was holding the steering wheel like this. And the one thing that was really very clear on the steering wheel was this topaz ring on his finger. Well, guess what he was wearing in court? So that took the fuzziness out of my reasonable doubt. But I have had, cases like that. I'm not going to keep you waiting. You know what, I didn't get to speed trap evidence, but there's a pretty good outline in what I gave you about speed trap. That's a really important part of it. And understand it only applies, traffic and engineering surveys only apply to radar citations, not to pacing citations. And it doesn't apply to local streets, it doesn't apply to construction zones, it doesn't apply to senior citizen zones. So, but it is an element of the offense. You have to have testimony about the traffic and engineering surveys, and the date of the survey, 5 years, 7 years, or 10 years, that pretty well speaks for itself in there. And the only other thing I'll tell you about hearsay authentication, sometimes defense attorneys will object to the calibration. Officer, were you present when the car was calibrated? No. Well, it's hearsay. How does he know it was calibrated? Well, it goes to weight. It does go to admissibility of the evidence. I don't admit any of that into evidence, and in fact, we've been asked not to admit physical evidence into traffic trials. It causes a lot of problems, and it's not necessary. So we have the officer submit the evidence, you review it, you read it, you review it, and you return it, reverse. And, that says preserve enough. Yes, Evan?
I've always done that, but last week, they said they just were told to mark it and keep it.
For
The
what?
officers were quite upset because they wanted their copies back, but that's what the
I
clerk
can
told
answer
me.
that. Westport, Commissioner Van Camp has determined that if there's evidence, it has to be physically retained by
A traffic and engineering survey, even though that's a matter of public record.
traffic and engineering survey, diagrams, calibration, post-training certificates, photographs, anything that
Well,
you look at that is going to be
I
an
understand.
exhibit gets kept now.
Well, we'll see. I don't know if that's going to continue, because that poses a great imposition on the courts for storage,
Exactly.
for booking, all that kind of stuff. Yes?
What I do is I do on the record state that this is People's Exhibit 1.
Yes,
So
I do.
return it and I specifically state what the document is for it to be on the record.
Right.
Because let's say if we were to keep all those documents, they would have to come in with, each time they would come in, those documents are quite lengthy. Some of
That's
them.
for sure.
And they're already laminating a lot of them. So I think that would just be a burden. Even in small claims, we don't take any evidence. We look
Right.
at it. Sometimes we do, but we shred it 5 minutes later because they, yeah.
I don't think it's practical to do it on, certainly not on traffic cases, but if that's what they want, we'll see. We'll see. My number, or my email's on here. If anybody has any specific questions, I'll be happy to respond to you. And again, I thank you all so much for being willing to help us all out in doing this. And don't hesitate to call if you have a question on the bench, if you've got something going on, and you want to take a timeout. If you call and tell my clerk, and I'm in session, I'll get off the bench for you, if it's something that's very urgent. So feel free to do that.
What's that number?
Well, 5414 is the clerk's number. That's Lindsay's number. And if you want to call, but if you want to email me, I'll respond to you if you have anything that you want to talk about. So thank you all so much for listening.